Alibis always sound so delightfully healthy, but they crack up dreadfully easily. Whatever the truth about his defense, Dave Ansey, it seemed, had total faith in it. As for me, I'm not sure that I like cast iron alibis. They're the sort that sink quickest to the bottom of the sea. The New Jersey Supreme Court had said that few defenses have greater potential for creating reasonable doubt as to a defendant's guilt in the minds of the jurors than an alibi. But is alibi a powerful defense, or a risky gambit with a high likelihood of backfiring? Courts and prosecutors contend that alibis are easy to manufacture and effective defenses. Alibi, some courts suggest, has long been considered as one of the main avenues of escape of the guilty. Other courts refer to it as a hip pocket defense because of the ease with which it could be manufactured for introduction in the final hours of the trial. Concerns about easy fabrication underlie notice of alibi rules found in many jurisdictions. Defense attorneys, on the other hand, frequently decline to offer alibi witnesses out of concerns that the jury will reject the defense after the prosecutor's clever cross-examination and summation, leading to the defendant's conviction. Appellate dockets frequently contain post-conviction cases arguing that trial counsel was ineffective for not investigating or not presenting alibi witnesses. These claims are rarely successful. My belief about alibis is that unless they're solid, they can get you into trouble. It's the last thing the jury hears if you have a good prosecutor who's a good cross-examiner and can try to kind of attack either a family member who's an alibi witness or some other vulnerability to the alibi. To me, it pulls attention away from the weaknesses in the state's case, and it kind of develops jurors' focus on the weaknesses in the alibi. So, it's just been my practice to shy away from alibis unless they're solid, and I had some concerns about the alibi in this case. Outing v. Commissioner, where trial counsel testified that she had ultimately concluded on the basis of her experience as a trial attorney that the presentation of an incomplete alibi defense, bolstered only by friends and relatives of the accused, often undermines the defendant's defense in a murder trial. Commentators warn defense counsel to exercise extreme caution in choosing alibi witnesses and take pains to ensure that the alibi witness's testimony is consistent with other defense witnesses. There is nothing as dangerous as a poorly investigated alibi. An attorney who is not thoroughly prepared does a disservice to his client and runs the risk of having his client convicted even when the prosecution's case is weak. So who was right? Is an alibi defense the key to the jailhouse door or a millstone? The DNA exoneration cases suggest the latter. In about 2/3, 68% of the DNA exoneration cases, the innocent defendants offered an alibi which was not believed by law enforcement. Worse, weak alibis were used by prosecutors as incriminating evidence at trial. Fact finders, it seems, underbelieve alibi witnesses. Defense counsel's concerns seem validated, and courts' fears seem overstated. Yes, an alibi can be fabricated, but so can almost all other testimony. Deciding whether an alibi witness is accurate and truthful is hard. It is easy for a suspect to make a good faith error about where he was when first confronted by police, and easy for potential alibi witnesses to make good faith errors about the details of what was for them an everyday event. Does defense counsel then abandon alibis unless they are complete and unequivocal, based on strangers and supported by physical evidence? The question falls largely on defense counsel because alibi is a reaction to the prosecution. Defense counsel investigates alibi witnesses and looks for confirming evidence. Counsel decides whether to offer an alibi defense, giving appropriate notice, and chooses what witnesses to present and how. Investigators and prosecutors are largely reactive. They follow up on information provided by the defendant and challenge the defense witnesses at trial. Insisting on only offering an alibi supported by physical evidence would mean very few alibis would be offered. Alibis supported by strong physical evidence are rare. Only 14% of alibis offered in a survey of American and Canadian cases were supported by physical evidence, but this may be changing. Cell phone location history, apps, and call records may document a witness or defendant's location at key times. Admittedly, these locate the device, not who's holding it, but it may be persuasive corroboration, even if not absolute. Smart speakers and assistants that capture voices at critical times would be hard to fabricate. Insisting on only offering an alibi supported by disinterested witnesses ignores the risk that the witnesses who are most likely to be believed are also the most likely to forget having seen the defendant. So what can defense counsel do? Basic research about perception, memory, and good faith errors should be familiar to attorneys and judges from eyewitness identification research and case law. There is also more specific research available on the psychology of alibis. Understanding what one can realistically ask of alibi witnesses and communicating that research to fact finders may lead to a more accurate assessment of alibi defenses and a decrease in convictions of innocent defendants. Where were you that night? The suspect and the initial questioning. My heart started pounding. I had gotten my weekends confused, which meant the alibi I gave to the police was not going to check out at all. An innocent suspect may first learn that he or she needs an alibi when first questioned by police. Questioning may occur soon after the crime when the suspect's memory of where he or she was should be fresh, but it may also occur days, weeks, or months later. The innocent suspect's memory of his or her whereabouts on a past date and time that had no significance until that moment may be wrong, but a good faith mistake may be interpreted as a deliberate lie. The Reed method cautions that where a suspect has an alibi, it is imperative that the alibi be checked, if at all possible, before the interrogation begins. If the alibi is defective, it will help the questioner. If not, it may actually establish the innocence of the suspect, despite other circumstances that may point to his guilt. The manual suggests open-ended questions to elicit an alibi, like, "Please tell me everything you did from noon on Friday until you went to bed." The manual suggests that information that is volunteered during a response to an open question, for example, a subject's alibi, will probably all be truthful, although perhaps incomplete, and then gives an example of a truthful answer implying an alibi but not actually committing to it. The manual suggests show gaps in the witness's story to provide details that could be tested. To test an alibi, the manual suggests asking the witness about a fictional event like a car accident that supposedly happened at the time and place mentioned to see if the suspect will believe the false event is true and add it to his story. The author assumes that the suspect has a clear memory of the evening and there would be no delay in saying that the event didn't happen, and/or asking the witness for a detailed description of his activities and then to recount the alibi in reverse chronological order. A person who has related a truthful account will have little difficulty doing this because their memories are based on factual occurrences. In practice, observers have noted that if a suspect offers an alibi, the interrogator will attack it as inconsistent, contradicted by all of the case evidence, implausible, and/or simply impossible, even if none of those assertions are true. Innocent suspects are more likely to waive their Miranda rights and talk to investigators. They believe, wrongly, that their innocence will be obvious to the investigators. This same illusory aura of innocence may affect alibi witnesses who expect that the truth of their testimony will be obvious to investigators and may be surprised when it's not. An innocent suspect may have no experience with a serious felony investigation and is likely to be unfamiliar with techniques used by police to obtain admissions and confessions. This may make the suspect more anxious to offer an alibi without taking the time to verify it. Cotton, an innocent suspect arrested a few days after Jennifer Thompson was sexually assaulted, confused his weekends and gave police the wrong information about where he was. This is not unusual. Innocent suspects may not accurately recall where they were in the past. In one study, participants were asked to report their whereabouts on 4 particular times in the past, then given 48 hours to return with evidence of their whereabouts. In this low-stress, low-stakes test, over 1/3, 36.4%, were wrong about where they had been. If the suspect in the high-stress, high-stakes interrogation room setting provides wrong information to law enforcement, officers may see this as a deliberate lie and as evidence of guilt. Cotton, like other witnesses, may have relied on a schema to generate his alibis. He recalled what he habitually did at that time on a weekend, rather than recalling specifically what he did on that particular day. If he in fact did what he usually did, the alibi would be reliable. If he did something different and had forgotten that he had deviated from his routine, then the alibi would be inaccurate. When police are unable to verify it, the suspect looks guilty. As noted above, acquaintances and strangers may not recall interacting with the defendant. If the defendant overconfidently assumes that the witness will do so, then he or she may suggest alibi witnesses who don't recall them when contacted by an investigator. If the alibi witness fails to remember the defendant when questioned, then the investigator may assume that the defendant lied to them and is guilty. The consequences of good faith mistakes are serious. Once a defendant makes a mistake, it may be near impossible for them to convince anyone of their innocence. The one exception seems to be if the defendant lies, then provides a salacious alibi. Changes, even changes that genuinely strengthen the alibi, tend to weaken how fact finders perceive it. Most people have trouble accurately recalling where they were in the past. In Newcamp's study of over 800 volunteers drawn from the community, asked about their whereabouts no more than a week earlier, 90% of subjects reported that they could support their alibi with at least one witness. 65% of those could provide a motivated, familiar person, and 16% could provide an acquaintance or stranger. About 25% could provide an item of physical evidence, typically a receipt. Only 7% believed that they could find video recordings to support their claim. Alibis were weakest during the times when a person was most likely to be at home with friends or at a movie, and strongest when the person was at work or in class. This study supports the general proposition the majority of a person's time, especially at night, on weekends, and during the holidays, is spent with family and friends, the weakest alibi witnesses. In State v. Dixon, the defendant first learned he was a suspect in a murder when he was arrested 18 months after it occurred. His mother and aunt repeatedly told police that he was with them at a sports bar on the night of the murder and asked them to contact the bar to see if it still had a recording to prove Dixon's alibi. Police did not contact the bar, which had a fire 6 months after Dixon's arrest. The Connecticut Supreme Court noted that neither of the alibi witnesses testified unequivocally that the defendant had been in the sports bar with his family at 9:30 p.m. on January 9, 2010, when the crime occurred. Moreover, to the extent that the testimony of the defendant's mother and aunt would support that conclusion, both witnesses had a clear motive to attempt to convince the jury that the defendant was in the bar at that time. What about strangers? Would the bartender or wait staff have remembered serving Dixon if asked a year and a half later? Unlikely. Unlike an eyewitness to a crime, an alibi witness has no reason to realize when they interact with the defendant that they will be asked to recall him or her later. The alibi witness may have interacted with dozens of people during that critical time and may not recall which customers were there at that time. What about supporting physical evidence? Suspects provide leads or references to physical alibi evidence in less than a quarter of criminal cases. In Dixon, the defendant's family believed that physical alibi evidence existed, but police did not try to obtain it before it was lost in a fire at the bar. In a survey of police officers, less than half, 49.2%, said that a thorough investigation of an alibi is always conducted before an arrest warrant is prepared or the defendant arrested. 38.1% said it is often investigated. 7.9% said it is sometimes investigated, and 4.8% said it is rarely or never investigated before the warrant is prepared or the defendant arrested. Telling the police about physical alibi evidence does not mean that it will be pursued. If the police fail to follow up on alibi information, the defendant could combine an alibi defense with a claim of an investigative failure or omission, arguing that a jury could find reasonable doubt if jurors conclude that the investigation was careless, incomplete, or so focused on the defendant that it ignored leads that may have suggested other culprits. This may be especially important to counter jurors' inherent belief that if a case makes it to trial, then there is a reason not to trust an alibi witness. If police had believed the alibi, the case would not have progressed to trial. Police and prosecutor questioning of an alibi witness. What happens when a suspect provides alibi witnesses to the police or prosecution? One survey of 73 prosecutors found that all but one took advantage of notice of alibi rules to make a pretrial investigation of alibi witnesses. Epstein theorized that pretrial investigations would lead to dismissal if the alibi proved true. 19% reported no cases dismissed after investigation. This includes a few respondents who said that they would not dismiss the case even if they thought the alibi might be true, because credibility was for the jury. Over half, 58%, reported a few dismissals. 15% reported dismissals in half their cases, and 8% said there were many dismissals. Epstein concluded that the fact that comparatively few cases are dismissed as a result of pretrial investigation is entirely consistent with our notion of alibis. They are usually false. There is another possibility, perhaps unknown to Epstein in 1964, tunnel vision and investigative bias. If the police have arrested the suspect, they have already formed a conclusion that he or she is guilty. When police form a hunch that a suspect is guilty, they may then, without realizing it, discount any evidence that does not jive with their prior belief in the suspect's guilt. Once prosecutors have filed charges and begun to prepare their case, they have likewise concluded that the defendant is guilty. The prosecutorial role inevitably fosters tunnel vision. Ethical prosecutors feel a pressure to push hard to obtain convictions because only a conviction serves the interest of justice. Similar confirmation bias issues may affect judges considering the effect of alibi witnesses on the strength of the prosecution's case on appeal, and whether trial counsel was ineffective for not pursuing or offering alibi witnesses in a habeas case. If the police or prosecutor are convinced that the defendant is guilty, then the alibi witness must be either liars or wrong. Disbelieving investigators may subject alibi witnesses to coercive interrogation methods, which may pressure witnesses to retract or hedge the alibi. Police or prosecutors may threaten alibi witnesses with prosecution for perjury or obstruction of justice. Accurate, truthful witnesses may be intimidated and either hedge or retract their statements. Even more subtle methods can lead witnesses to retract an accurate, truthful alibi. Witnesses exposed to incriminating information may doubt their own memories or fear being seen as lying for the suspect and prosecuted, and soften or retract an alibi. Both truthful and false alibi witnesses may not recognize or respond when police test them with altered versions of earlier alibi statements. If counsel becomes aware of an alibi witness before a police or prosecutor's interview, counsel may want to take a statement to preserve the original alibi from further contamination by suggestion, post-event information, and pressure. If counsel first becomes aware of the alibi witness after a statement was given, counsel should see if the interview was recorded and talk with the witness to see if coercive tactics were used. Why didn't you go to the police? The alibi witness after arrest. Sometimes alibi witnesses do not go to the police and instead go to the defendant's family or defense counsel. In State v. Geer, the Connecticut Supreme Court stated that although we do not believe that an alibi witness has a duty to report an alibi story to the police, or for that matter, to any other person, a witness in many instances naturally may be expected to convey such information, especially when the witness is friendly with the accused. Failure of the witness to do so would, under those circumstances, constitute grounds for impeachment because the failure to report an alibi under such circumstances is relevant on the issue of credibility or, more specifically, the issue of fabrication. A review of the Geer briefs shows that this assertion is based on judicial experience. Neither party provided the court with research into how alibi witnesses behave. The Geer opinion is akin to the historical belief discussed a decade later in State v. Trope that any normal woman would report a rape soon after its occurrence. The clear implication of this assumption was that if the woman did not complain, it was likely no rape had occurred. The Trobe Court recognized that indisputably, one of the historic premises of the doctrine that it is natural for the victim of sexual assault to complain promptly following the assault has been discredited substantially in contemporary times. The overwhelming body of current empirical studies, data, and other information establishes that it is not inherently natural for the victim to confide in someone or to disclose immediately following commission of the offense that he or she was sexually assaulted. Alibi research does not yet have an overwhelming body of empirical studies about witness behavior, but there is enough research to suggest that those assumptions are flawed and should be abandoned. As one court observed, it is lamentable but undeniable fact of modern society that some of our citizens harbor a mistrust for law enforcement authority, which leads them to shun contact with the police, even when the avoidance of contact is not in their own best interest. Witnesses may be afraid of the police in general, or may have immigration issues, child custody issues, or pending criminal charges that make them particularly concerned about contradicting the police narrative. If the case has received significant media attention, the witness may be afraid of becoming part of the story. The witness may be afraid of disapproval from the victim's families or friends. Witnesses may believe that once the defendant has been arrested, going to the police or prosecutors, even with a strong alibi, will not lead to the end of the case. The further along the case is, the less likely it is that exculpatory evidence will lead to a dismissal instead of giving the prosecutor time to prepare an attack on the evidence. In the year 2000, a commission of inquiry was established in Manitoba, Canada, to look into the exoneration of Thomas Safano, falsely convicted of murder. The commissioner made a number of recommendations. As to alibi evidence, he suggested that the witness be interviewed by officers other than those involved in the investigation of the offense, that any interview with an alibi witness be recorded in its entirety, that the witness be treated with respect and courtesy. The witness should not be cross-examined. Leading questions should not be used. Police should not suggest that they are mistaken, threaten, intimidate, or influence the witness to change their story. No empirical research exists to show that alibis presented early in the criminal investigation process are better for an innocent suspect. To avoid good faith mistakes, an innocent suspect may want to wait until he or she can confirm the alibi, even if that means waiting until the eve of trial. Most jurisdictions have procedural rules requiring defense counsel disclose an alibi to the prosecutor prior to trial. Counsel should keep these requirements in mind and make proper disclosures. Whether to offer an alibi defense. An alibi is not a traditional affirmative defense. It is a response to the prosecution's case. Logically, an accurate and truthful alibi means that the prosecutor's witnesses have misidentified an innocent defendant either through good faith witness identification mistakes or through deliberate lies by co-offenders or cooperating witnesses. Alibi defenses may work well when combined with arguments about mistaken eyewitnesses, lying informants or cooperating witnesses, and investigative failures or omissions, including a rush to judgment and ignoring exculpatory evidence in the investigation. If the prosecution's case is based on physical or forensic evidence establishing that the defendant was at the crime scene, then even an accurate, truthful alibi may be unpersuasive. The defendant may have had innocent access to the area and left DNA or fingerprints prior to the crime. Video evidence is often unclear and may result in a mistaken identification. Forensic evidence may be tainted by confirmation bias if the examiner was aware of intrinsic inculpatory information at the time of the test. Counsel needs to consider the relative strengths of the prosecution and defense cases and the seriousness of the charges. Counsel should consult colleagues to see how the prosecutor in this case has cross-examined alibi witnesses and argued about alibi in closing. Counsel then needs to think about the alibi witnesses and any corroboration of the alibi. Counsel should make the decision whether or not to present an alibi along with the client. Admittedly, decisions about which witnesses to call and what defenses to raise are traditionally within trial counsel's discretion. When a client is represented by assigned counsel, he or she has no right to his choice of counsel. Unless the defendant can show circumstances mandating a change of assigned counsel well before the start of trial, he or she either cedes to his assigned lawyer trial management decisions or waives his right to counsel under Ferretta v. California. Those ceded decisions included what arguments to pursue, what evidentiary objections to raise, and what agreements to conclude regarding the admission of evidence. In McCoy v. Louisiana, the defendant decides whether to plead guilty, waive the right to a jury trial, testify in one's own behalf, and forego an appeal, and sets the general objectives of his defense. In McCoy, Justice Alito contends that the criminal justice system would break down if defense counsel were required to obtain the client's approval for every important move made during the course of the case. Among the decisions that counsel is free to make unilaterally are the following: choosing the basic line of defense, moving to suppress evidence, delivering an opening statement and deciding what to say in the opening, objecting to the admission of evidence, cross-examining witnesses, offering evidence and calling defense witnesses, and deciding what to say in summation. It is the client's future that is at stake in the trial. The client should have some input on the decision of whether or not to present an alibi defense. It may be important to the client that his or her family testify and demonstrate the client's innocence, even if that risks weakening the case. The final decision is counsel's, but if the client feels strongly about it, counsel should expect to have to defend the decision in post-conviction proceedings. In one survey of prosecutors, 81% of respondents said that alibis were only occasionally successful. 11% said that they were successful about half of the time, and 8% reported more frequent success. If the defense is aware of potential alibi witnesses but uncertain whether it will rely on an alibi defense at trial, then it may want to delay notice until a decision has been made. Notice must normally be given in time for the prosecution to investigate the alibi witnesses if it wishes. In outing, trial counsel was concerned about potential alibi witnesses who would say that the defendant was less than a mile from the crime scene shortly after the murder. None of the witnesses could pinpoint the defendant's location at the exact time of the shooting. In that case, deciding to offer the alibi witnesses and disclosing them to the prosecution could have weakened the defendant's case. Similar problems could arise if the alibi witnesses described the defendant wearing something like descriptions of the culprit around the time that the crime occurred. When did you realize you had exculpatory information? Witnesses who are casually acquainted with the defendant might not realize that they can provide an alibi. Witnesses may be uncertain about dates or times. For the witness, the crime may have occurred when he or she was doing something routine and had not paid particular attention to specific times or places. Sometimes the exact time or location of the offense is uncertain. Not only could witnesses be unsure if they could provide an alibi for that time, investigators or forensic experts who become aware of a strong alibi may subconsciously reconsider the evidence and change their estimate of time or location to still support the defendant as culprit. Did you have a motive to exonerate the defendant? Most alibi witnesses are the defendant's family, friends, co-workers, and other people who know the witness well. They call these motivated witnesses. This is normal. One spends the most time around one's family, friends, and co-workers. Unfortunately, police and jurors tend to be skeptical of motivated alibi witnesses. If the crime took place during business hours on a weekday, the suspect's alibi witnesses are most likely his or her co-workers. If it took place late at night or on a holiday, then the suspect's alibi witnesses are most likely family. Expecting the suspect to be able to provide neutral alibi witnesses for most dates and times is unrealistic. Would you lie for the defendant? What about the popular assumption that friends and family are likely to lie for the defendant? In one study, 62% of jury-eligible participants felt a biologically related alibi witness would be most likely to lie for a defendant. 50% felt the same about someone related by marriage, and 32% felt the same about witnesses socially related to the defendant. There is some research about when people are willing to provide false alibis. In one study, 23% of participants were willing to corroborate a false alibi, regardless of how much they liked the suspect. Witnesses were less likely to lie when the witness had seen evidence pointing to the suspect's guilt than when there was ambiguous evidence of guilt. Unfortunately, truthful witnesses are more likely to retract an accurate alibi if exposed to incriminating evidence. It is really hard to separate an alibi provided in good faith from a lie. Study after study shows that people are not good at accurately assessing deceit. In most cases, investigators and fact finders would be just as accurate if they flipped a coin. This makes it hard for investigators and fact finders to assess an alibi witness. The DNA exoneration cases suggest that there is a systemic bias in our justice system against alibis provided by innocent suspects. Could you be mistaken? The police or prosecutor may suggest that an alibi witness has made a good faith mistake, confusing the date, time, or identity of the defendant. It is not an unreasonable argument. The alibi witness had no reason to realize that he or she would have to recall details of their interaction with the defendant days, weeks, months, or years later. Counsel may want to look at the eyewitness identification case law in their jurisdiction to ask for jury instructions on perception, memory, and the effects of after-acquired information and suggestion. The jury should have some guidance about how much accuracy they can realistically expect from a witness, be it the prosecutor's eyewitness or the defendant's alibi witness. Can I offer an expert witness? If your jurisdiction allows you to offer an eyewitness identification expert, you should be able to offer an expert to talk about how perception, memory, suggestion, and so on work in the alibi witness context. If the prosecutor's case is built on flawed eyewitness identification testimony, then you may already be planning to offer an identification expert and can ask your expert if he or she can also look at and talk about alibi witness research. Closing argument. Prosecutors are given significant discretion to comment on alibi witnesses in their closing argument. Expect the prosecutor to ridicule your witness. Be wary of prosecutorial closing arguments that stray into impropriety by vouching for the state's witnesses. Improper comment on prosecutor's belief in defense witnesses' credibility. Improper attack on defense counsel as suborning or soliciting perjured alibi. Shifting the burden of proof. Prosecutor can recount testimony about police attempts to contact alibi witnesses without shifting burden of proof. Implications that the defendant or alibi witnesses had a duty to come forward to police. This can become an improper comment on the defendant's right to remain silent. The prosecutor arguing about what he or she would do to protect a loved one. Object to improper arguments, ask for curative instructions, and preserve the record for appellate review. In conclusion, alibi is an important defense for the innocent defendant. Prosecutors and judges are skeptical of alibi witnesses, perhaps overly so. Defense attorneys seem reluctant to offer all but the most rock-solid of alibis. The result may be a loss of accurate, truthful alibi testimony supporting innocent defendants. There are a growing number of research articles about the psychology of alibi witnesses and how they are perceived by investigators and jurors. As yet, research does not know much about how easily or often alibis are fabricated, whether they are reliable cues for an investigator or fact finder trying to evaluate an alibi, how jurors actually react to incomplete or partial alibis, and how well jurors follow jury instructions when weighing alibi witness testimony. Investigators and prosecutors should consider the effects of investigative bias and tunnel vision when they evaluate an alibi witness. The Softenau recommendations to fairly evaluate an alibi should be used more often. Investigators and prosecutors should be prohibited from threatening alibi witnesses with criminal charges. Defense counsel should investigate an alibi witness, even if he or she is skeptical about using an alibi at trial, and document that investigation. If counsel decides to present an alibi defense, then he or she should carefully prepare the witness for contact from the prosecutor and/or police after disclosure, and for inevitable cross-examination questions at trial. Counsel should be prepared for a vigorous closing argument and alert for prosecutorial misconduct or impropriety in cross-examination or closing. Counsel should consider expert testimony about perception, memory, particularly autobiographical memory, suggestion and after acquired information, and good faith mistakes in appropriate cases. Courts and counsel should consider jury instructions about perception, memory, suggestion and after acquired information, and good faith mistakes to give jurors a proper framework to evaluate prosecution and defense witnesses alike. Thanks for listening.